Yes, please stand up.
What rise?
No, hang on a minute, we're not here yet. Not at the door yet. Are they ready now? Okay, come on. Knock on the door.
What rise? Appeal in the matter of Triumph Controls UK Limited and another, and Primus International Holding Company and others.
Thank you. Yes, good morning.
Yes, may it please the court. You know, I, together with Miss White, appear on behalf of the appellant. Mr. Pillai, Queen's Counsel, and Mr. Bird appear on behalf of the respondent.
Yes.
My Lord, I understand that we have 4 hours allowed for the case today. Whilst I'm sure neither my learned friend and I would wish to expand the time to fill the space unnecessarily, we had provisionally agreed that I would open for approximately 1.5 hours, subject to judicial interest and intervention. My learned friend would then have 2 hours spread either side of lunch, and I would have then approximately half an hour reply.
Yes, well, on any view, there should be plenty of time for what is, after all, a pretty short point of construction when one gets to it.
Yes.
If it helps, we've all done, I think, the reading which we were asked to do in your skeleton, and we obviously read the skeleton arguments and had a look at most of the, or at least some of the authorities. So I think we can get down to the real argument fairly swiftly. But not that I'm trying to prevent you from...
Well, no advocate likes to tell the judge what they already know, and no doubt if I stray into that, you'll encourage me along pretty quickly. I should say there's transcribers who are doing it remotely via the YouTube link.
Yes.
They require a break, but I understand they're prepared to wait for the hour and a half tentatively outlined for my submissions before
Yes,
their first
well, that would obviously be the appropriate moment. Yes, okay,
yes.
well, let's fire ahead then. Thank you very much.
So the brief roadmap of my submissions is to deal relatively briskly with some matters concerning the facts and the judgment, then to get hopefully reasonably quickly onto the meaning of goodwill in this context, then to deal with other matters relevant to construction, commercial purpose, redundancy, the fact it's an exclusion clause, and issues of consistency, and then finally to deal with the respondent's notice point. And just in relation to that, of course, there are two broad questions. What does it mean? And depending on what it means, what effect, if any, does that have on the claim for damages? And the judge addressed the first question in her judgment. Because of the finding she made, she didn't address the second question. But of course, I'll need to do that contingently to abide the event the court is with me on the first point. My lords and my lady, the overall structure of the transaction we had set out in our structure chart, which was attached to the skeleton, is found behind tab 5 at page 49.
I think we were supplied with a corrected version of that last week.
Yes, I'm grateful, and
Yes.
sorry for the inconvenience previously. The correct version was with our original skeleton, but an error when we filed a replacement. The definitions in quotations on the left-hand side are those to be found within the SPA.
Yes.
The judge referred to the top company on the left as PCC and the top company on the right as TGI. She referred comprehensively to the 3 green companies as Primus and the 2 red companies as Triumph, and that was a perfectly clear way of doing it. The acquisition is in respect of the target group, which one can see in blue. And although there were 4 companies involved, the real value, which we'll come to, was in relation to the bottom company, Farnborough, which had facilities in Farnborough, unsurprisingly, and the Thai company, which had facilities within that jurisdiction. Now, as the judge held in her judgment, and I don't think I need to take you to this, between 48 and 50, the target group, and generally I should refer to the first judgment as the judgment, unless otherwise said. The target group was forecast to be loss-making in 2011-2012, was forecast to make a profit during 2013. And the court will have seen that was premised on the basis of a transfer of programmes from the UK to Thailand and the establishment of new programme capability in Thailand itself. Such is the way of the world, it's cheaper to manufacture in Thailand than it is in the UK. In terms of the facts leading up to and shortly after the SPA, if I could take the court in the first judgment, which is in the core bundle behind tab 8 at paragraph 57, which the court will find at page 88. The original non-binding indicative bid on the 1st of October was 60 million on a cash-free, debt-free basis. The meaning of that expression may be already perfectly clear to the court, but it is just worth noting, if the court could keep its finger there, going through to 171. And paragraph 474.
So page 171.
Yes,
Yes.
lady, and paragraph 474. That the offer of 60 million was based on a mistake made by Mr. Kornblatt on behalf of Triumph. He thought the net book value was 59.1 million, which had then been rounded up. But in fact, the asset value was 59.1, but the net book value on a cash-free, debt-free basis was 45.5 million. Hence, he made an erroneously inflated original offer.
Perhaps you can just help me. I mean, the expression cash-free, debt-free, could you just explain that?
Yes, no cash left in the business, doesn't owe any debt.
I see. Simple as that.
Yes.
Yes.
And in a moment, I'll take your lordship to the PEG accounts, which contain the target value for various matters, which refer to that. The price was increased to 65 million to secure exclusivity, and then the ultimate price was 63.5 million, which the court knows. The reason for the reduction from 65 million is not relevant to this appeal. In terms of the split as the price, the court looks at paragraph 68 in the judgment at page 90. The judge there set out clause 3.1 as attributed 33.5 million as the consideration for the shares and 30 million by way of payment of outstanding debt. I should say there's clear from the judgment and all the other matters that that was accepted that 65 was the purchase price, even though it was allocated in that particular way. And then subsequently, the completion accounts were prepared, which resulted in Triumph paying an additional purchase price of 30 million,
Yes.
taking it to 76. On one reading of paragraph 69, the net book value of Primus was fixed at 46.5 million. But I think that may not be quite right, because your lordship will recall when we took you to the paragraph where the erroneous error had been made by Mr. Kornblatt, the judge referred to the net assets of 45 million at the stage when the offer was made of 60. The subsequent completion accounts procedure added 13 million. So it may be more accurate to say the net assets was fixed at 58 million rather than 46 million. In any event, either of those figures were substantially less than the overall price. On that, if I could take your lordships to the supplemental bundle and to Triumph's 2014 accounts.
So it's not something that's in the judgment. Checking for myself, I'm always very nervous when we start looking at evidence because
Yes.
we're already introducing the prospect of island hopping.
Yes, well, I obviously read what your lordship had put in when granting permission to appeal. When
Designed to make a crisp
yes,
hearing rather than island hopping. So we're looking at accounts for what purpose?
to show, as I said before, there are two questions. One, what does it mean? And two, what might be the consequences of that? I want to show your lordship the accounts for 2014 to show how Triumph treated the purchase and the distribution of the purchase price in its own accounts, which I don't say is relevant to the first issue of construction, but might be relevant to the second issue of what are the consequences.
So these are the consolidated accounts of TGI, is that right? Of the Triumph Group.
That's correct, my
Inc.,
lord.
yes.
I'm not sure if the court has looked at this in its pre-reading, but the material part starts at page 20.
Yeah, bottom paragraph.
Well, that's quoted in your skeleton, isn't it? Yes.
Yes, and then you've got over the page,
Oh, sorry, maybe it's the other side skeleton, but anyway, it's no, it is yours,
I
yes.
think it may be me.
Yes.
Over the page, there's then a breakdown of how it was put. So, total assets of 115,000, including goodwill of 29, deductions of total 52,246, which if one takes that off from the other leads 63.5 million, which was the agreed price before the 13 million adjustment. Triumph attributing 29 million of that in respect of goodwill, with the balance therefore being referable to what we might describe as identifiable assets.
But this is a condensed balance sheet in accordance with an accounting standard, 805.
Yes. But that point specifically being directed at the acquisition of the Primus companies and the total net purchase price being identical to that which was agreed at the time of the SPA.
I mean, the general point you're going to need to grapple with is really what is the relevance of these accountancy concepts to what looks like a pretty standard provision in a commercial sale and purchase agreement relating to shares, in the context where what is being bought is a loss-making company which is expected to become profitable. And in that situation, projections about future profitability are absolutely central to the whole deal, and one therefore expects a warranty to be something that has some teeth.
Yes, well, 2 points within your lordship's point. One is, to what extent does the accounting treatment and definition have any relevance to the meaning of goodwill?
Yes.
And I'm going to try and do that in stages. And then the second point is, can the warranties in the agreement, including 19.5, have any meaning if what I say is right?
Yeah.
And I will address both of those. Hopefully to the court's satisfaction, but I'll certainly address them.
Thank you.
So, my lord, that's the account, and the court knows from the judgment the TGI had used what was referred to as a TGI model to assess, I use that word carefully, the price that it should pay. Because although the original offer was based on net assets with an error, they used the TGI model as a cross-check, which was a form of discounted cash flow, which produced a value of 92.5 million. Just while we're on accounts, and just to, as I said I would, in terms of the adjustment, if I could just take your lordships to the SPA, which is back in the core bundle behind tab 17. The adjustment provision is in clause 4, which is at page 287. And to cut a long story short, one compares actual value to target value with an adjustment either up or down, depending on that. The target accounts, which have been referred to by both of us in our skeletons, at least on issue 2, the what are the consequences, start at 355. This is in relation to the Thai company. Is the one for the UK, which follows a very similar format. I don't think we need to look separately at it. But your lordship can see that the target cash is effectively 0, which is the cash free point. One turns to page 359.
Sorry, where do we see the cash being 0? At which page?
So 355, my lord, there's effectively a large splodge.
Oh, I see. Yes.
Yeah, so we're not targeting any cash in the bank at the target,
Oh, I see.
in the target.
Yes. Sorry. Yep.
Yes, it's sort of wood for trees sort of And then goodwill, after one goes through various pages and other kinds of assets, at 359, in the last section, one will see a reference to goodwill and other intangibles,
Yes.
including customer relations, which are recorded at 0 and the target is 0. And my learned friend and I make different points arising out of that same document.
And these figures, it took me a little while to realise they're all in Thai currency, aren't they? Which is,
Yes. Yeah. And if one was to look at the UK accounts, now
they're in sterling.
they're in sterling.
Yeah.
And then there was a US dollar adjustment.
Yes.
So page 359 is in baht.
Yes.
Having claimed that with a specialist knowledge, I shall now stay quiet for the rest of the
I suspect your Lordship may have some more points to make in due course. Your Lordships will have seen that the Clause 8 contains the warranties, and Schedule 3
Yes.
then sets out what I think are at least 28 warranties with various sub-warranties. I don't think I need to take your Lordship at the moment to warranty 19.5, which wasn't necessarily central at the trial, but is now obviously central on this appeal. And what the judge ultimately concluded was, if the forecast had been properly prepared and carefully prepared, the price would have been 5.7 million lower.
Yes.
And after the deduction of the contractual deduction of 1.5 million, she awarded 4.2. My Lord, perhaps worth looking at briefly Clause 9, which I suspect the court's already looked at. 293.
Yes.
Which is described as limitations on claims. It deals compendiously, at least by way of introduction, with Clause 9 and Schedule 8. There isn't on the face of it a hierarchy between Clause 9 and Schedule 8. Clause 9 is divided up into, I think, 4 or 5 sections with different exclusions. Schedule 8, then, which is at 375, is headed Limitations on Liability and Conduct of Claims. It does contain, in my submission, important matters, including, for example, before getting to the clause in question, paragraph 2, which deals with obligation to mitigate, and in 2.2, precluding a remedy of rescission, which, depending on the facts of the case, could have particular significance. Paragraph 3 then contains various provisions, including the one in question, to which I will need to return.
Is there any significance in paragraph 1, page 375, or does anybody take a point arising out of the carve-out in relation to the warranties at paragraphs 1, 2.1 and 3.1 to 9 of Schedule 3?
No one's expressly taken that point, no.
All right.
I looked at those and they seem to be so utterly fundamental
Yeah.
that one couldn't expect that liability would be excluded for them.
Thank you.
And it goes that far and no further.
Thank you. I interrupted you.
It suggested my learned friend's skeleton, and this may touch on one of the points Lord Justice Coulson made, that we're trying to overturn the judge's findings of fact and to take a different approach to the quantification of damages. I'm not seeking to do that. As I said, there were 2 questions. The judge didn't answer the second question. And if the court is with me on the first, we have to look at the second one. And I said, in any event, the judge's findings are consistent with Triumph paying a price for the shares that was in excess of the net identifiable assets. In other words, there was a top-up for goodwill in at least the accountancy sense. That begs the question as to whether or not it applies in the sense referred to in the agreement.
Yes. I mean, is it fair to say that one wouldn't, on the first blush, if you look at the wording of clause 3.1 little f, the matter to which the claim relates is in respect of lost goodwill, I mean, that just doesn't at first blush sound like appropriate language to describe an accountancy concept of the kind that you're arguing for.
What I'm going to seek to persuade the court is that there is, in truth, no real conflict between the accountancy approach and what might be described as the ordinary meaning, and that the ordinary meaning itself is bound up with the question of value. And I hope, in a moment, to get to some of the cases, including those referred to my learned friend, where one actually sees goodwill and value almost being used as interchangeable terms. And so it would be...
Well, goodwill has a value. I mean, everyone would agree on that. But as to what goodwill is, I mean, not everyone begins with Lord Macnaghten's famous statement in the margarine case. And that is surely fundamentally the normal legal meaning of that phrase.
Yes, but what one is looking at, has there been a loss of goodwill?
Yes.
Now, if goodwill is fundamentally about value, it is, in my submission, a short step or no step at all to say that loss of goodwill is equivalent to a loss of value. In other words, a loss of share value. You paid more for the shares than you would have done, which is then called by the exclusion. Now, I could...
But again, from a normal businessman's perspective, that just means you bought shares which weren't worth what you were told they were worth. I mean, that just doesn't really engage with issues of goodwill at all, does it?
That depends on how one looks at two ways. One is, was the breach of warranty in respect of identifiable intangible assets, intangible assets? Is the claim for damages properly one which is regarded as in respect of the net assets, in respect of space, it's not caught by the clause, or is it in respect of effectively the excess over the top, which is created by reputation and so on and so forth, but is valued and paid for on top?
Yeah, well, I mean, one quite sees that is an accountancy concept which accountants use to describe the difference between the asset value of what has been bought and the purchase price which has been paid.
Yes.
I mean, in order to make the balance sheet balance, you have to describe it as something. But is that the sense in which, on a natural reading, informed by the normal legal meaning, this wording conveys on an objective footing? I mean, that's the nub of the case.
Yes, well, can I take your lordship's...
Sorry, I'll stop interrupting you.
There's nothing worse than if a judge sitting there with his arms crossed for an hour, not saying a word and not giving you a chance to address
You'll have gathered I have some difficulty with your primary case, so, but anyway, that's what you're here for, is to persuade us.
Well, I hope to show the utility of oral argument rather than the futility.
Precisely, yes, thank you.
What I propose to do is just take it in stages in relation to that, and then of course there is the counterpoint, which is how could this argument, my learned friend's argument, well, if there was a claim for breach of, for loss of reputation, that's what's intended to be caught by this clause, which for reasons I'll hopefully explain is rather unsatisfactory explanation as to how this clause could operate.
But that's very much a secondary position. Because the first position is you have to persuade us that this exclusion clause bites.
Yes, although if the court came to the conclusion that giving it the meaning of just simply reputation meant it never had any practical or realistic application.
It bites on this claim.
Yes, well, I suppose...
We might engage in some of the philosophical stuff around the edges, but the key point is, does this exclusion clause exclude this claim? Because if it doesn't, then that's the end of it.
Yes, and
I'm not here to sort of answer a linguistic exam about what the clause might have meant and where it might be relevant. I mean, that may become a material question, but the real point is, does this clause exclude this claim?
yes, I mean, as I said at the start, there's the two questions. What does it mean? And then, depending on the meaning, what does it exclude?
It's the first question you need to be focused on.
And I was, though I think your lordship was trying to take me on to the second question.
No, it's the first question, does this clause bite on this claim?
Well, I hear what your lordship says. Obviously, I propose to break that down into what is the meaning, and then how does that apply to this. The judge's reasoning in relation to this at 496 is concise, and I don't criticise the judge for that when she's already produced a long judgment. And
She had a lot to deal with, didn't she?
yes, and the focus on this claim, as this point, has become exponential as opposed to the focus at trial. The first point I'd like to make is it's clear from Inland Revenue and Muller that goodwill is comprised of a much wider variety of elements than simply, quote, business reputation. It depends on the business in question, and it must be attached to it. And whilst my learned friend says it's just a shorthand for everything we ordinarily understand, that shorthand, in my submission, leads to the likelihood of not giving full effect to the meaning and the consequences of that. Is the court familiar with the facts of Muller? I can give you the 20-second version if that would be of assistance.
I mean, vaguely, it was the German business which was carried on entirely in Germany and had no connection with the UK at all.
Yes.
And it arose in a rather different context. I mean, in relation to a stamp duty.
Yes, and indeed I think all the cases we refer to are often in quite different circumstances.
Yes.
Do
you want us to look at it? I mean,
yes, I do want to take
you the key case.
tab 7 in the bundle of authorities. Various assets were sold, including goodwill and indeed some customer contracts. And the price that was apportioned to those elements was around 77,000. There were other elements apportioned to other parts of the business. And as your lordship has said, it was held that stamp duty was not payable because the goodwill was effectively in Germany rather than in the UK.
Yes.
We've both in our skeletons quoted at least 2 or 3 of the judgments. I wanted to although the court will have read it, take your lordship to 223, which is the judgment of Lord Macnaghten, which starts at the bottom of the page and carries over. The particular point I wanted to draw your attention to in support of this first point is 3, 4, 5, 6, 8 lines down on 224. Goodwill is composed of a variety of elements. It differs in its composition in different trades and in different businesses in the same trade. One element may preponderate here and another element there. The judge went on to say the emphasis on locality. I think it's right to say that in the 21st century, the emphasis on locality for goodwill may be rather less than it was in the start of the 20th century. But the point I'm making there is it's a variety of elements which depends on the trade in question. Then Lord Linley at 235 in a similar vein, but perhaps clearer as to the scope. 235 next to the marking we've put on. Whatever adds value to the business by reason of a situation, name, reputation, connection to introduction to old customers, and agreed absence from competition, or any of these things, and there may be others which do not occur to me. In this wide sense, goodwill is inseparable from the business to which it adds value. And there is just a sort of starting point as to the connection between goodwill and value to which I'd alluded earlier.
Mr. Morgan, can I just go back to your introduction to this case, where my note, and hopefully live note, it confirms, you said that goodwill being accepted as shorthand leads to the likelihood of not giving full effect to its meaning and consequences. What do you mean by that?
So it's not just reputation, it's anything that adds value to the business by reason of its situation, name, reputation, connection, introduction to all customers, and agreed absence. And then crucially, that there is this very close connection, I'd say effectively 2 sides of the same coin, between the elements that make up goodwill and the creation of value.
And the
creation of value.
Creation of value, thank you.
My lords and my lady, there is a more modern example of elements of goodwill in the PwC document, which I quoted in my skeleton argument. That is in the supplemental bundle at tab 14. Most helpful bit is at 105, third paragraph down. Goodwill is the residual in a business combination after all the identifiable assets, liabilities and contingent liabilities we
I'm sorry,
recognise.
Mr. Moore, we're on page 105, which paragraph?
I'm sorry, my lord. Third paragraph down, starting goodwill is the residual. And they include, and I would say there's no inconsistency with Inland Revenue and Muller in this respect, assets that are not capable of recognition, e.g. skilled workforce, non-contractual customer relationships. So,
But this is a concept which is being used, and only in the limited context is this right of the acquisition of a business, and when a price has been paid for it, and you're looking for the right label to describe the portion of the purchase price which is not attributable to the net assets, tangible and intangible,
that's,
of the company you're acquiring, is that right?
that document is specifically in that context.
Right, yes.
But I would submit that there's no inconsistency in the identification of other categories of elements which make up goodwill, such as skilled workforce and non-contractual customer relationships. That would fit in equally with the definition of goodwill, or the description of goodwill, given by Lord Lindley and Lord McNaughton.
Yes, but again, one comes back to the question, as a matter of construction, is that the kind of goodwill which is being focused on in the particular warranty exclusion that we're concerned with? I mean, it wouldn't normally cross one's mind, would it, if one saw the statement of claim, the particulars of claim in this action, to describe this as a claim in respect of loss of goodwill. That's just not the way a lawyer would talk about it.
Well, I wouldn't accept that.
You wouldn't, no.
as a proposition, my lord. And one of the reasons I say is, of course, this is a commercial agreement, but it's for the sale of shares.
Yeah.
And where there is an identifiable amount being paid for net assets, but an excess on top of that being paid by reference to the discounted cash flow forecast.
But I mean, steady on, the purchase price isn't described as being a price in respect of net assets plus an add-on, is it? I mean, it's just one global price, which no doubt one can, for accountancy purposes, one needs to break down in the way which this document tells one to. But from a businessman's perspective, what matters is whether the shares are worth the money you've paid for them. And if it turns out that they're not, because you were presented with negligently prepared forecasts of the upturn in the business expected over the next few years, I mean, that looks to me like a claim for, in colloquial terms, being sold a pup, rather than for a claim in respect of a loss of goodwill.
Well, Lord, what my learned friends seek to do is to draw a bright line distinction between what your lordship has described as the ordinary meaning of goodwill and the accountancy approach. Yeah. And what I'm trying to say the court to do is say that that bright line distinction is not properly made. I mean, for example, in Inland Revenue Commissions and Muller, they paid for the goodwill, for the exclusive right to use the name and everything else associated with it. If because there had been some unknown flaw in the ability of the business to produce certain quantities of margarine was not as valuable as it was believed to be, it wouldn't be a misuse of language to say they'd suffered a loss of goodwill. They had paid $77,000 for goodwill, but in fact it wasn't worth as much as that. My submission is that's not a misuse of language to say they had suffered a loss of goodwill, or there had been lost goodwill as a result of, for example, breaches under that contract. My lord, the linkage of goodwill and value can also be seen in a number of the other authorities which have been referred to by both sides from a variety of different sources. Going back to the 19th century, If I could take your lordships and your ladyship to tab 3.
Mr. Moore, just before we look at the authorities, just for my notes so that I'm clear, I understand what Mr. Pillai's definition of goodwill is. In your skeleton, just so I get the boundary of the dispute before we look at the authorities, which is the best paragraph for your definition?
Well, can I give you my definition now?
Well, I'd rather look at it and read it, unless it's not in your skeleton.
We've put it on the basis that it covered this. In the skeleton, we've put it on the basis it covered this claim. I think I could probably express it slightly more precisely.
I understand that, hence the question.
Yes, well, I apprehend that, my lord, and I'm not going to duck it, but perhaps if I can give you what I say, that lost goodwill in this case includes a loss of share value, where one, that value represents the difference between the cost of acquisition and the fair value of its identifiable net assets.
Sorry, it's
Sorry.
my fault. Can you just go a little more slowly? Lost goodwill includes a loss of share value where one...
That represents the difference between the cost of acquisition and the fair value of its identifiable net assets, and or where that loss of share value is
Acquisition and the fair value
of its identifiable net assets, and or is where that loss of share value is caused by impairment of the value of non-identifiable assets.
is caused by the impairment.
Of the value of non-identifiable assets.
I understand why you say that may be, in one sense, all you need to do, but in answer to my Lord Justice Coulson's question, as a matter of construction, what would your positive case on identification, rather than your negative one, as it were, the overarching definition of goodwill, rather than it includes, what is the definition?
Yes, well, in that case, I could put it as is.
Right, so lost goodwill is... Lost goodwill, in your definition of loss of goodwill in the relevant clause is as you've given it to us.
Yes.
Thank you.
If it's convenient, perhaps I can go back to authorities.
Yes, sorry, you were going to take us to a 19th century case, I think.
Yes. We're covering a wide span of
None the
cases,
worse for that.
and a period of, I think Muller was only just into the 20th century, and slight defence of the point I'm making. And the case of Austin and Boys at tab 3. My lords and my lady, there's a number of points in this case which don't need to trouble the court. Can I show you on the second page of the report the second paragraph from the bottom, which quotes Article 11 from the partnership deed between those then solicitors. And it gave the power of the partners to retire and for the surviving partners or partner to pay such retiring partner for his or their interest and share in goodwill in the business, the fair marketable value thereof. Now, Mr. Austin gave notice of retirement one day before the partnership was due to expire. And it was held that in those circumstances he couldn't be paid for his goodwill. It would have been different if he'd given his notice a year or two before, while the partnership persisted for a significant period of time. If I can take the court then through to the fourth page of the report, 1136. It's the paragraph starting just above where we've marked it in the margin. And the Lord Chancellor said, it's very difficult to give any intelligible meaning to the term goodwill as applied to the professional practice of solicitor in this abstract sense. The abstract sense there was without having regard to the terms of the partnership. He said this, where a trade is established in a particular place, the goodwill of that trade means nothing more than the sum of money which any person would be willing to give, I would say pay, for the chance of being able to keep the trade connected with the place where it is being carried on. he then goes on to say that goodwill is distinct from the profits, but in determining its value, the profits are necessarily taken into account. So what I submit the Lord Chancellor is doing there is drawing that direct link between goodwill and value, which is relevant to how one might interpret it in this commercial context. My learned friends referred to the Veuve Clicquot case in Canada.
So, sorry, isn't that saying that goodwill is separate from value?
Well, I've submitted he's not saying it's different, and if he is saying there is a difference, it's a very slim difference, and it means that value and goodwill, as I said, are effectively two sides of the same coin. So when one sees the word goodwill, it can be read as synonymous with the value that's produced.
I'm slightly puzzled that way of putting it. I mean, of course, goodwill is an asset which has a value, and then that leads to the question of how do you value it? And then, as it said here, it's often done as so many years' purchase of the annual profits, that being a standard way of calculating it. But I mean, to say that it can be valued, and there are various techniques for valuing it, it's not really to make a link, is it, or to say that goodwill is value, or in some deeper sense.
The only reason that the elements have commercial importance is because they produce value for the business.
Yes.
I mean, there is that absolutely inseparable link between them, and people are not interested in goodwill other than that, which is why I effectively say, if you are acquiring the goodwill, you are acquiring value, which is based on it, and there is no significant or proper distinction to be drawn between them when reference is then made to the goodwill. And one sees this theme in my submission in many of the authorities that have been referred to. The Veuve Clicquot case, which is behind tab 20, which related to the well-known champagne brand bringing proceedings for alleged infringement of its mark and goodwill. At the penultimate page in the report, we've only provided you with an extract. There's a quote at 50 where it doesn't in any really advance us, because it's a quote from a Northern Irish case quoting and commenting upon it. But at 51, if I could draw the court's attention to the reference to Lindley and Banks on partnership, the expression goodwill when applied to the business is generally used to denote the benefit arising from the connection and reputation, and its value is what can be got for the chance of being able to keep that connection and improve it. And again, in my submission, there is that direct link between the two. One does not have, on one hand, the elements of goodwill, which are entirely separate from the valuation of it. They are, in my submission, to be looked at together. The other line of cases are those in relation to the A1P1 point and European Convention. And I accept those are actually a separate jurisdiction, but it doesn't mean they don't have anything valuable to say when one is drawing on cases from different areas of law in relation to the same type of expression.
But we have to be careful, because we are here dealing with a concept which has an autonomous meaning in EU law, and therefore is not really by definition a definition for the purposes of the domestic English law.
Well, I fully accept that. And what I wanted to do is to take you to the Breyer Group case, which is behind tab 6, where Lord Justice Coulson was the judge at first instance. If I could start...
Referring to the Court of Appeal judgment very wisely instead.
I think they upheld your lordship,
I was, yes.
so no conflict.
I mean, we have to bear in mind, I mean, I'm sure there may be material here that's valuable. I mean, obviously I've looked at this and one or two of the passages in the then Master of the Rolls judgments I think are helpful, but we have to bear in mind that all of these cases is struggling with this concept of possession under A1P1 and the difference between goodwill on the one hand, which potentially is a possession, and loss of future income on the other, which isn't.
Yes.
And that's the mould into which claimants in these cases try and fit their claims, and what the court is doing is seeing whether or not that's an appropriate categorisation of the claims in question.
I entirely agree with that, and there's this rather sometimes difficult to draw distinction as to when you've got a current value of goodwill as opposed to just the prospect of future profits, which wouldn't fall, whereas the former would.
Yeah.
It seems to be, in my submission, fairly clear that if you have an established asset, then you have established goodwill as a result of the reputation of the business and everything else, then that constitutes goodwill for the purposes of this jurisdiction. When one can get into difficulties is, for example, with professional persons such as doctors, who are not allowed to transfer their practices, so it's not marketable, one gets into difficulty in that respect. I don't think there'll be much doubt that in this, if the business of Primus and the companies below had been affected by some external event for which the government was responsible, that the value of the businesses wouldn't have constituted goodwill for the purposes of A1P1, because it was an established business with goodwill. My Lord, the paragraph I want to take to is paragraph 44. Where it is,
Oh, well, that may be your best point in answer to my question, Mr. Morgan. It's not susceptible to precise definition.
yes, I can have credit for footnoting this in my skeleton. I perhaps would have got more credit if I'd quoted it in my skeleton. The important point here is, first of all, that. Secondly, they refer to Muller. And then, having referred to Muller, they say the same idea was expressed by the European Court. That's paragraph 45 in the Van Maal case. And then they go on to say, or Dyson goes on to say, possession comprising the goodwill of a business is a product of past work, by dint of their own work, applicants have built up a clientele. Goodwill is the present value of what has been built up. Goodwill is it is distinguished from the value of a future income stream, by which they mean purely a future income stream that cannot be capitalised or marketed. From the accountant's point of view, this makes little practical sense, but it's that distinction which has been clearly drawn. So perhaps that is the clearest expression, whilst in a different jurisdiction, said to be consistent with Muller, that goodwill is the present value of what has been built up. Therefore, if someone pays above the net assets for a business, that is part of the present value, and it's part of what might be called the term goodwill.
I mean, I see you can take from this that, according to Lord Dyson, this really is the same idea being expressed in the European context as that which we find domestically in the Muller case.
Yes. Yeah. There are other passages within Breyer referring back to Kenneth Parker, but I don't think that improves my argument. I'm not saying it damages it, but that, I think, is the essential point I wanted to draw out of that. And following on from that, which I think is the third sort of building point, I would submit that ordinarily there's not an inconsistency between the technical accounting definition and goodwill in a commercial context.
Well, just to say no inconsistency is not enough, is it? I mean, you've really got to show that what you're calling the accountancy concept is a matter of construction, what the parties are to be taken of handing having had in mind in the particular clause we're construing.
The accountancy definition certainly assists me, but having looked at some of those passages, my submission is that this bright line distinction between the elements of goodwill and the value it produces is not a sound one. And that the fact the accountancy definition is of assistance is obviously something I rely upon, but I fundamentally say one shouldn't draw that bright line distinction, which my learned friend seeks to do. One of the last authority on this, the balloon productions case, promotions case, which is behind tab 4. I'm not sure if in particular your lordship is familiar with this, being from the tax jurisdiction.
I confess I wasn't until I looked at it yesterday, but I mean, this is a decision of a special commissioner, so I mean, interesting, but not perhaps very high up the judicial hierarchy in terms of authority.
No, well, my learned friend relies on it. I felt I ought to make some points about it.
Well, this is drawing a distinction, whether it's a bright line or a fuzzy line, it is drawing a distinction between the accounting definition and the...
Exactly, yeah, and the normal legal meaning.
Could I perhaps just unpack that a little? Your lordship is quite right, Justice Coulson, that 147, that's paragraph 147 rather than that's page 196 in the report. That the expert for one of the appellants had relied on the accounting definition. The judge's, or the Special Commissioner's conclusion at 152 was that that definition was deficient. But it was in that very specific context. That specific context was because you had to identify what meaning of goodwill was within that tax statute. And the Commission was concerned, possibly, didn't say actually, that identifiable assets other than goodwill could be categorised as goodwill. And so that was the particular concern that led him not to apply it. But he did say, in any event, it would be relevant. And, my lords and my lady, the conclusion he reached, perhaps it's the last page we've provided you with. Mercifully, we haven't provided you with all the report. Could I invite you to read, if you haven't already, 248 and 249, rather than me read that out.
So the accounting treatment is relied on as additional grist to the mill in the last sentence of paragraph 249.
That is right. The particular point I also relied on is at the start of 249, that the added value, as represented by the excess consideration, conforms with the salient features for the concept of goodwill. That, in my submission, draws that link very closely, if not inseparably. He is saying, in my submission, added value above net assets equals goodwill. So, where I'm seeking to get to obviously for this court to decide whether I have, is that there isn't a presumption, as my learned friend has said, that the ordinary legal meaning of goodwill is the elements of it, as opposed to the value that it produces over and above the identifiable assets of the business. So, just pausing there before looking at other aids or possible aids to construction. What we say the consequences of that are is that, firstly, if Triumph, if the portion of damages identified by the judge related to the excess above the tangible net assets value, that's precluded by the clause. And we say that that is indeed what happened in this case, because the purchase price was in excess of the net assets.
Sorry, could you say that again?
So, the damages that were awarded are 5.7 million,
The overpayment.
yes,
Yeah.
related to the top, effectively the top slice that was paid over and above the net asset value of the company.
Then, that's goodwill, you say?
Yes.
That's,
Yeah. Thank you for making me make the point I should have.
That was over and above the net. That related to the top slice, you say, over and above the net assets.
Yes. It's anything over net assets is goodwill. The 5.7 million was only in respect to that top slice. Therefore, it's lost goodwill because they overpaid for the shares.
It's a very odd use of language to describe that as a loss of goodwill, it seems to me. I mean, you may be saying you paid too much for something, but that's not a loss, is it? I mean, it's not a loss of goodwill. It's just a you paid more than the thing was worth.
It's certainly a loss of value.
Well, I mean, damages, obviously, if they're going to be more than nominal, they must reflect a financial loss of one kind or another.
Yes, and the measure of loss is, depending on precisely how the warranty is worded,
Yes.
the difference between the price as warranted and the actual value of the shares.
Yes, and there's no dispute about the basis upon which damages, or at least no longer any dispute about the basis on which damages were calculated in this case.
So what the claimant is saying is, I've suffered a loss of share value. And what we say is, that is indistinguishable from a loss of goodwill, because it's that loss of value which is attributed to the purchase price over and above the identifiable net assets.
was the claim for loss of share value? Or was it a claim by reference to overpayment? Because the damages were awarded by reference to the amount of overpayment. That's how the 5.7 was arrived at, wasn't it?
Yes.
The finding of fact that you sought unsuccessfully to appeal was the finding that, but for the warranty, or but had the true position been known, 5.7 million less would have been paid.
Is you paid too much for the shares.
Yes. So it wasn't a claim for loss of share value. It was a claim for an overpayment. Have I got that right?
I suppose I have to be slightly careful, because in the ordinary case of breach of warranty, it is simply the difference between the price of the shares as warranted and the actual value. It was a slightly different analysis here because it was based on the reasonable forecast, and what would the reasonable forecast would have put.
And that was explained by Lord Hoffman in the passage from the, I forget what the case is, but anyway, cited by the judge.
But if I just remind myself how the judge put it.
It's the difference between what the position would have been had reasonable care been taken in making the forecast
If I,
on the one hand and what was actually paid on the other.
although 496, which is the concise determination of this point, the court will see how the judge put it, which was expressly loss of share value.
Well, lost revenues and increased costs leading to reduced profitability and loss of share value.
Yes, and I'm not sure
A number of things.
Yes, I'm not.
And it could be concisely summarised as we overpay.
Yes, but if one said in an ordinary case where you had an absolute warranty rather than one to take reasonable care, and you're claiming for loss of share value, what the claimant's really saying is, I overpaid for the shares. They weren't worth what I thought. I paid too much. My submission is not a realistic distinction to be drawn.
In fairness to you, Mr. Morgan, if we look at the second judgment at paragraph 71, page 191, tab 10, having regard to the compensatory principle of damages for breach of warranty, I am satisfied a fair and reasonable basis for assessing Triumph's loss is the reduction of value of the companies.
Yes.
But it was reached by her the London judge's finding as to what sum would have been paid had the true position been known.
I accept that is a slight nuance on it, but my submission is that there's no material difference.
There wasn't any expert evidence. Yes, there was expert evidence. Was there expert evidence as to the effect of the breach of this warranty on the share value? Or was it just factual evidence as to what would have been paid had the true position been known?
The expert evidence was used to recalculate the discounted cash flow forecast.
And it was by reference to that the factual witnesses said, had I known this, this is what I would have been prepared to pay.
Yes, they didn't quite go that far, but the judge's conclusion was,
Yes.
although they didn't say it, this is what would have
So there was no expert evidence valuing the reduction in share value by reference to this particular breach of warranty.
I can't claim to have encyclopedic recollection of all the expert
Sorry,
evidence,
if I'm
not least because I wasn't the trial
counsel.
counsel,
I know.
but it's certainly right that there was lots of expert evidence dealing with sort of the simple share warranty breach. They had to recalculate their figures on the basis of the findings the court have made. And
Just so you know what I'm thinking, and in fairness, I'm sure I may be alone, but was the judge right to talk about loss of share value? In fact, she was measuring damages by a different route.
yes, well, perhaps I can make a note of that and come back to
Yes, sorry.
ownership on that as well. So, I think I was dealing with the point about top slicing and making that payment. Another way of looking at it, and this was how it was put below by Mr. Pepperell, as he then was. If I could take the court, please, to his skeleton argument for trial, which was then substantially replicated, I think, almost word for word in his closing submissions.
Is that in the supplemental bundle somewhere?
Yes, tab 2. Just a short extract from his opening skeleton argument. If I could take the court to paragraph 120 and 122. And having done that, I'll then take you to one more paragraph. court has had a chance to look at that, it may just be helpful at this stage to look at 123.4 over the page, and in particular point A.
Yeah. Well, I take the point it may not be a wholesale exclusion, but does that really meet or go very far towards meeting the point that it would nevertheless rob the warranty of any real value in what is likely to be the most important situation where it's going to be relied upon, which is where one comes back to the point this was a loss-making business expected to become profitable, and where therefore future projections are absolutely crucial. A mistake in those projections is not going to leave you with a remedy. In a situation where ex hypothesi you're likely to have paid well above the net asset value because it's in the expectation of future profits that you're buying this as a going concern and hoping that it will turn itself around in the near future. I mean, surely that is what the businessman is going to be particularly concerned with.
Yes, although I appreciate this is something of a double-edged sword for me. I mean, the agreement already contained within Clause 9 substantial restrictions on the claims that could be brought.
Yes, but they're carefully crafted to strike a balance, as one would expect, between the interests of both sides, not to negate an absolutely fundamental part of the commercial background to the deal.
So I'll need to come back to the question of negation in a moment. But for example, I mean, unless you've got outside the warranties claim, which Triumph sought to do by reliance on Clause 6.6, the claim was capped at 15 million, which on any view is a relatively small proportion of the overall purchase price that was paid. And indeed, depending on the figures, and the goodwill exclusion, as I contend for, may have produced a lower figure than that in terms of a cap. Insofar as the claim was sufficiently large to start to effectively eat into the price paid for the net assets, then the exclusion would cease to apply. And the exclusion would also cease to apply, insofar as Mr. Pepperell put it, which I endorse, if you could identify effectively impairment or damage to a non-identifiable asset. And just to give the court an example of that from Triumph's own document, and while we're in the supplemental bundle, I can take the court back behind tab 6 to page 20. Under the heading Acquisition of Primus Companies, the last two lines, the company has also identified intangible assets relating to customer relationships valued at approximately 3.5 million. Now, that was an intangible asset, but nevertheless an identifiable one. If, just as an example, if, for example, the forecasts had been carelessly prepared in relation to that type of asset, so that those figures were overstated and wrong, I would accept that would not be caught by the goodwill exclusion, because it would relate to, the matter would relate to a identifiable asset as opposed to an unidentifiable asset.
Even though it's goodwill.
That is, there's a distinction between, obviously not all intangible assets are goodwill.
Well, I understand that, but that particular, the example that we're looking at is said to be goodwill, isn't it?
No, that's separately identified, my lord. In the heading, in the table over the page, you've got goodwill in at 29.1 million. Below that, you've got intangible assets at 3.5. And so it's a separate category of intangible. Crucially, it's identifiable in a way that goodwill isn't. And the court may or may not recall when we looked at the PEG account.
What is that?
So that will be existing customer relationships, I suspect.
Which would be caught by the legal definition of goodwill.
Well, I'm not sure I agree with that.
I mean, I'm sure it's just me. My concern is that it becomes very murky if you get into differences between, for example, tangible and intangible assets.
That's a point made fairly by Mr. Pillai, and I recognise there is some force in that argument. What I say is it's a detailed commercial agreement. One can see from the trial how complex the claims were in respect of breach of warranty, notice and all the other issues. I would submit that that doesn't add a particular additional complexity that's not already inherent in the nature of the agreement. And I'd want to then to sort of under the heading of commercial purpose, just to explore my learned friend's approach to it. As part of his example of how difficult this could be, my learned friend refers to Warranty 25, which is the anti-bribery and corruption provision. And perhaps I could just see how he puts this in his skeleton argument, which is back. Your lordships and ladyship may have it separately taken out, but it's in tab 6. And it's his paragraph 48. I should say, my friends their paragraph 48, with all due respect to Mr. Bird. What is said is 48. Its function is to exclude any claim for damage to reputation, good name, etc. If the companies had in fact breached the anti-bribery provisions, Triumph could well have suffered loss, I think actually loss or harm to its good name, reputation and business connection, in addition to having overpaid for the company's shares. The lost goodwill exemption would bar such claims for consequential loss. I have some difficulty in understanding how such a claim could ever arise. And it goes back to the measure of damages for breach of warranty, which, if it's a simple breach of warranty, is the difference between the value as warranted and the actual value, or in the slightly more nuanced situation of 19.5, at what price would have been paid if the forecast had been properly made. I struggle to understand how one could have an additional and separate consequential loss claim for reputation or indeed anything else. One can see that if bribery had an effect on the reputation, that could have an effect on the share value, but that would be reflected in the standard measure of loss. One wouldn't then need to resort to consequential loss of reputation. And one struggles to see, at least from my perspective, how that could ever possibly operate.
Well, it might all depend how the loss of share value was quantified and calculated. But I mean, in principle, it's possible to conceive of a situation where a breach of those provisions might have had reputational impacts, which could be quantified in monetary terms, and if so, could be the subject of a claim. I mean, that's recognised, I think, in one of the authorities Mr. Pillai refers to in the skeleton. I forget which one. It was Lord Denning, I think.
Anglo-Continental.
Thank you, Anglo-Continental, yes.
Yes, I'll come back to that. But I mean, I appreciate the court won't hang on necessarily exactly as my learned friend has put it, but he put it as in additional to having overpaid for the company's shares.
Yes.
But any overpayment...
Not saying that would anyway factor in the reputational loss.
So how does this then ever have operate? And then there's perhaps a linked point, which is how can one say that the breach of warranty damaged the company's reputation? The damage to reputation would have been caused by the underlying facts which had already taken place. It's very different from the Anglo-Continental situation, where you have action by defendant breaching contract, which then directly affects the claimant's relations with its customers. One can see how the breach of contract then sort of follows through. But in this case, the breach of warranty, say, doesn't cause the loss of reputation, unlike in those types of situations. So that's another reason why it's difficult to see, and my learned friends obviously thought it important to strive to give it some meaning for obvious reasons of construction, to see how this could ever work. In relation to those, that's a convenient point just to mention those other cases. The first one referred to as fominol. Not sure if
Yes.
the court looked at that in its pre-reading, but it's on any view, it's a slightly odd case.
I looked at that because I was surprised and impressed to see that Lady Hallett, as she now is, was dealing with these complex questions, but I realised by the date that in fact it was not Lady Hallett at all.
She wouldn't thank you for
No, she would not.
That's an observation.
Don't tell her.
She's not here to defend herself.
That's an observation that can only come from the bench. The plaintiffs in this case were suppliers of cosmetics and were planning the launch of a summer cream, as you do, which was to be promoted by the beauty editor.
Yes, it's a very entertaining case to read, actually. It's a period piece.
Yes, after doing that, then read some P.G. Wodehouse. But they entered into a contract with the defendants for some containers, but they didn't fulfil their obligations. There was no doubt it was a breach of contract, and there was a question of various heads of loss. The actual head of loss in claim in this case was in fact goodwill in the sense of friendliness, which is not the goodwill we're talking about
Yes.
at all. So one has to put it in that context. I apprehend my learned friend is relying on it really by way of the contradistinction. So that is at 399.
Well, you're quite right to point out that goodwill is there being used, at least in that paragraph, in a much more sort of colloquial sense, and is said to be quite different from the loss of goodwill in the legal sense. So in that sense, the judge at that point is regarding the concept as having a legal sense separate from the sort of friendliness and desire to help.
Yes, I apprehend my learned friend relies effectively on the contradistinction referring to the butcher selling bad meat or poisonous ice cream.
Yes.
And he says that's consistent with a legal meaning.
And then I think you may also rely on the passage over the page at 400, where it says, if pecuniary loss can be established, the mere fact it's brought about by loss of reputation caused by a breach of contract is not sufficient to preclude its recovery.
Yes, and I can see why he relies on that, and effectively a similar point is made in the Anglo-Continental case.
Yeah.
The way I invite the court to look at those cases is really to say it's about breach of contract and loss of profit. Because what you're really saying is, as a result of your breach of contract, I'm not going to get the sales that I'm going to get in the future. And that's a recognised head of loss, which one sees subject to questions of foreseeability. The cases don't seem to be saying much more than the fact of, if you can prove the direct loss of sales, then you don't have to rely on reputation. But if reputation comes in as sort of in the middle, it doesn't preclude you from bringing that claim. They seem to be quite a long way from really saying that damages can be claimed for breach of reputation. And if they are, they're talking about reputation in quite a narrow sense.
Well, I see what you're saying, and it may be any such claim would be difficult to bring and might have evidential problems and so forth. But I mean, that rather makes the point, doesn't it? That it's that kind of rather optimistic but definitely nuisance value claim which the warranty is there to exclude. I mean, that's what you expect. It's something at the margins you want to eliminate from the arena, just as a matter of cutting off what might be an optimistic attempt by ingenious lawyers to bring a claim, rather far-fetched claim, for a loss of goodwill on top of a loss of share value or something of that kind. Whereas your construction does actually, as it were, go to the very heart of the claim in this particular case, which, and I've said it before so I won't say it again, but does seem to me unlikely to be contemplated objectively unless one has very clear words. And I certainly don't for myself find this very clear, the wording we find in Schedule 8, paragraph 3.1f, as being clearly directed to the nature of the claim in the present case. But anyway, that's That's, I'm afraid, the way I'm still inclining to see it. But anyway, please do carry on.
When you're climbing up a mountain surrounded by fog, it's at least helpful to know whether you're supposed to go up or down from the position you're in. And I apprehend I still have to go up.
Well, you may get through the fog into a sunny upland.
Well, I've touched on the principle of redundancy, and really what I encapsulate the point as is the unlikelihood of such a claim in respect of breach of reputation as a matter of sort of general approach, and in the specifics of this claim, should lead the court to look at the meaning in the context that in the manner we seek to ask it to do so.
Yeah.
And you have the authorities about redundancy, which I don't need to take you to.
Yeah.
And I've also given the court examples of how a claim could still arise, both in relation to eating into net assets and, admittedly, with some need then to work through the consequences, identifying claims in respect of specific assets. So that does give it meaning, as opposed to treating it essentially as something that was there just in case, but unlikely to have any real force.
Yeah.
And I think that's probably as well as I can put that. An allied point, I suppose, which is what we've both referred to as contra proferentum and Gilbert Ash. I just want to take your lordship through probably and your ladyship through one or two cases. Triumph have referred in their skeleton to Swiss Atlantique, which in turn referred to a case called Kudos. I'm sure the court knows that Swiss Atlantic was decided at a time when fundamental breach was still part of the doctrine. And the particular passage that my friend is quoting in his skeleton makes it clear that outside fundamental breach, it is still a question of contractual construction. Moving slightly more recently, can I take the court behind tab 13, please, to the Nobahar Coulson case? This was a decision of the Court of Appeal, the leading judgment given by Lord Justice Briggs, as he then was, about the meaning of an exclusion clause. Could I, and there was some debate whether it was contra proferentum or Gilbert Ash, and he made it clear that he regarded those as separate principles. And at paragraph 21, which is just below the highlighted section, included, as he did there, and perhaps I just invite the court to read that. Now, in that case,
Sorry, just to be clear, so 18 and 19, he's talking there about the principle of parties not lightly agreeing to cut down their remedies. What you've encapsulated as Gilbert Ash.
yes,
Yes,
exactly.
right.
The issue in that case was they'd either given up rights or they hadn't, depending on the events that had happened. One can have a situation where, we say in this case, it's undoubtedly the case that some rights have been given up. It's a question of categorising and classifying what those rights are. And that distinction was made by the Court of Appeal in Transocean.
Just before we leave, you made the point, which I completely understand, that Gilbert Ash and the principle of contra proferendum are separate. We've looked at the paragraphs dealing with Gilbert Ash. Is there anything here about contra proferendum?
No, essentially, Lord Justice Briggs says, I'm not really interested in contra proferentum.
No, I mean, nobody is. Is that right? I mean, it's been a long time since I've seen a case that's been decided on that principle.
Yes, it is. It used to be in the top drawer, now it's in the bottom drawer if ever to be opened.
Yes, fine, okay. Well, because I understand the Gilbert Ash point, but the contra proferentum point does seem to be something of a lame duck these days.
Yeah, I apologise if I got it wrong, but I think my learned friend specifically mentioned it in the skeleton, but I would agree with your Lordship's analysis. So, the Transocean case, which is behind tab 19 in the bundle, the panel was Lord Justice Moore-Bick and also Lord Justice Briggs, and it was decided just a few days, I think, or a few weeks after the HUD Group case had been decided. Could I take the court to be as economical as I can? Paragraph 20.
There we are.
You're in good company, my lord.
Well, if this is the judgment of Lord Justice Moore-Bick, then I'm in possibly the best company, yes.
20 is really context. 21 is the one I really wanted to ask the court to read.
Completely follow paragraph 21, you need to know that Providence was a party in the proceedings.
Yes.
And it was not a reference to the wider concept.
If I look at paragraph 59 of the respondent's skeleton argument, it doesn't seem to be inconsistent with any of the authorities we're looking at. If, contrary to Triumph's primary submission, there is any ambiguity, the commercial implausibility and impracticality. No, perhaps, which paragraph is it that there's reference to the contra proferentum argument?
That's 55.
55, thank you.
Yeah.
I see.
I think read in isolation, I think that's... It shouldn't be read in isolation, it needs to be looked at in isolation in light of the more recent cases. And the particular point that whilst inevitably the court is going to be cautious about rights having been given up, where one has a case where rights definitely have been given up, it's just a question of what they are. That's a less powerful point than whether or not rights have been given up. It's in a binary sense. We know they were prepared to give up rights, just a question of categorising it. And the approach then to construction is rather less, and Gilbert Ash has rather less vigour than it would do in the situation of total exclusion. And one knows from the contract that in a number of respects, Triumph gave up rights. My Lord and my Lord and my Lady, I'm coming up to an hour and a half, and the last point before dealing with the respondent's notice, which I could probably take in reply, if that's convenient, is the alleged inconsistency with other clauses in the agreement, which in a sense is a bit of question begging throughout.
I think if you could leave that to reply, I don't think it would be, that probably would be the best way of dealing with it, unless either of my
Yes, fine.
colleagues take a different view.
I just wanted to make just one brief point, which is in relation to clause 13, which is the protection of goodwill clause,
Yes.
which is a commonly seen provision in such agreements. the reason those are in is not to protect the goodwill in some abstract sense of reputation. It's to protect the value which you've paid for. And those go hand in hand. And in my submission, clause 13 is consistent with the meaning that we seek to put forward.
Yeah.
And if the court is with me on that, it doesn't matter if the other two clauses are maybe slightly harder to square with it, because then you've got at least two meanings of goodwill within the agreement. It, in my submission, doesn't make sense to limit those simply to the elements. What the purchaser is concerned about and what he wants to protect is the value for which he's paid for. My lady, I think that is round about an hour and a half. So the points I haven't dealt with in reply are on the respondent's notice. That's in my skeleton, and I can deal with that and reply. Unless I can assist any further at the moment.
Well, thank you very much indeed, Mr. Morgan. That's been very helpful. Anything else? Sorry.
Thank you very much.
Yes. No. Good. In that case, we ought to have a short break now anyway, I think, for the transcribers. And perhaps so we can rise and consider where we are. Thank you very much.
It's clear it's the difference in the price paid. I'm gonna need the loo, Johnny.
Okay, just start there.
Do you think I've got time to run to the loo?
I don't know. If suddenly come back, then maybe I better get them back in.
Well, if they're there, do you know if they're there or not? Otherwise I'll run upstairs.
I don't know when they went. It's hopefully.
I've got 4 minutes. I'm going to do it. I'll be very quick.
Back in. I didn't say.
Did you say that's what I said? I thought I missed that. Sorry?
Shoot 10 minutes. Screenshots of my friends.
Yes, Mr. Fry.
My lords, my lady, I'm mindful of the indications given by the court as to what you're likely to be most interested in. I have three headline points. The first is that Primus's construction doesn't accord with the natural and ordinary meaning of the language used by the parties. We've dealt with that at length in the skeleton, and that's been traversed in the course of argument already. We say that the ordinary meaning of the word for commercial men in this context and women in this context is also reflected by the legal meaning that's reflected in the case law. Reflected by the legal meaning. So you get to the same result, my lord. The second point I make is that Primus's construction leads to an inconsistent reading of the word goodwill within the SPA, and that point is actually given even more force by the expanded definition that my learned friend gave in the course of his submissions. We say that that expanded reading simply can't be the sense in which it's to be understood across the restriction of competition clause, for example, as well as elsewhere in Schedule 8.
So that's clause 13.
Yes, clause 13.
Yeah.
Yes, indeed. And then the third point, which I'm going to focus on, is as regards the fact that this construction of the exclusion leads to illegal and commercial nonsense, we say. As my Lord Justice Henderson pointed out, this clause is one that excludes consequential loss claims for loss of goodwill off the back of a breach of warranty. We've given some examples of such claims, and we say that that's what the limited exclusion bites on. Now, the court talked about Fominol. We don't need to pick that up. The points are made. Fominol, my lady, is the
Yes.
decision about the beach.
So I thought I was hearing the builders, that's why I looked over. That was.
Sorry.
You'll have to, both of you have to speak up slightly. We're slightly under attack. We have builders in the corridor and we have builders in Bell Yard. So bear with us and shout.
I will do, my lord. The other case that we cite in the skeleton argument is the Anglo-Continental case in this context. And, my lord, that's the one, perhaps it's worth taking that up. It's in the authorities bundle at tab 1. And that's a case in relation to a cruise booking which went wrong, and the defendants tried to substitute a ship. Passengers were unhappy. Holiday company cancelled the booking and sued. And the defendants tried to rely on an exclusion clause to the effect that a steamer might change. But that was rejected because the court held that that was changing the substance of the contract. The key point
It's 66, is it?
is page 66, my lady, indeed. And it essentially says that it is most unusual, I'm looking on the right-hand column, Lord Denning's speech, about halfway down. It is most unusual in a case of breach of contract for damages to be given for loss of goodwill, but in principle, I see no reason why it should not be given. And as I think my Lord Justice Henderson also pointed out, it might be difficult to formulate and prove loss under that head, but that doesn't mean such clauses are impossible. Now, the learned friend says, well, look, those are breach of contract cases, but this is breach of warranty and that's very different. Well, it really just depends on the facts, and one can see a hypothetical, for example, in a case where there is an acquisition of a company and one finds out and a warranty is given as to no bribery, or perhaps for a US company or something that's important, no dealings with companies that are subject to sanctions regimes. And say it's a US company and it finds out a year later that its acquisition, to whom it's given its name, had been dealing in breach of US sanctions, whether to Iran, China, wherever. One can see that in those cases the primary claim is for breach of warranty, and one comes to the court and says, well, look, I'm entitled to compensation for all of the loss that I've suffered. Now, I take my learned friend's point that the usual, the prima facie method is that one says, well, look, if it's a breach of a warranty of quality, then you look to the diminution in value of the shares. But that's only a prima facie basis. The court's always looking to establish, well, what loss has actually been suffered and how can it be fairly compensated. And in that sort of case, one can see that you have the prima facie case for compensation on the usual measures, say, but equally the claimant company may say, well, look, I am now tarred by my association, having brought into my group of companies this company, which it turns out had all of these trading relationships in breach of sanctions, and now my local clientele, my loyal customers for my whatever the product is, are now shunning me. Another hypothetical, perhaps.
So in that example, the
My lord, yes.
goodwill would be the goodwill of the claimant purchaser of the company.
Yes, I say I've lost goodwill because of a breach of warranty.
It's not the goodwill of the, in your example, the US company you've purchased.
No, I was saying that actually the purchase is a US company, but yes, it
Yeah,
does.
I mean, I'm just using your example.
Yes.
Yeah.
It could be a major bank which buys a subsidiary in Mexico. It finds out that that subsidiary has been in breach of all sorts of money laundering regulations for years. Again, the purchaser company's reputation is tainted by having brought within it. One more hypothetical is drawn from one of the cases that is mentioned in Halsbury's footnotes, but I haven't got it before your lordship. But it's another Lord Denning judgment. But say a company produces forklift trucks, and it buys the axles for its trucks, and the producer of the axles says, well, there's a minimum load-bearing requirement on each of these, and it's warranted in the contract for sale of the axles that each axle can support £17,500. It turns out that those axles are put into forklift trucks which are sold all around the world, and those axles can't bear that weight. That's a breach of warranty. The primary claim is against the producer of the axles for not producing, for breach of that warranty. But equally, they say, well, I've sold forklift trucks around the world now, and they're not, those trucks are not fit for purpose, and so I don't want to buy them from you. I'm going to go to another supplier of forklift trucks. There again is a potential claim for consequential loss for breach of warranty, claiming loss of goodwill, and that's what these clauses bite on, we say. And it's a short point, but we say that beyond that, in order for my learned friend's case to come home, he has to persuade the court that the definition of goodwill in this exclusion can countenance, barring all claims for breach of warranty, other than ones that allege the assets of the company that were acquired were not as valuable as warranted. And that requires the court to incorporate that accountancy definition, and it's reverse engineered by that reference to look at how the loss might be accounted for in the acquirer's balance sheet. And as the court has already observed, it means that no claim could ever be brought for breach of warranty 19.5. My learned friend has not answered that. It's, we say, a profoundly unrealistic outcome on the circumstances. And I'm going to go to some of the other warranties that show that they do not relate to existing assets, or certainly do not obviously relate to existing assets. And so therefore it's impossible to tell whether a claim for breach of those warranties is going to be caught by this exclusion. And we say that that could have very far-reaching consequences for what is a relatively humble boilerplate clause at the back of a contract. So with that opening, we've already touched, my lords, my lady, on the meaning of goodwill in the authorities. And I just wanted to pick up one further point in relation to the PwC guide, which I don't need to take it up for now, but my learned friend took the court to it. It was at the back of the supplementary bundle, and it talked about some of the factors that might support recognising goodwill in the balance sheet as a matter of accounting theory. We don't shy away from those, because of course there is some connection between the commercial meaning of goodwill and the specialist accounting concept of that name. And for example, the non-contractual relationships of a business will form part of its goodwill in the sense defined by Lord Macnaghten. But it doesn't mean that the two concepts are synonymous or can be substituted for each other, or still less, that they come within the same very broad umbrella, because that means there's this, I think my Lord Justice Coulson may have said it makes it very murky. It makes it a sort of amorphous clause, which is effectively exercising a sort of exorbitant jurisdiction over all other sorts of warranties within the contract. And we say the important difference between the concepts can be demonstrated by the following proposition. 1, all businesses may have goodwill in a commercial sense, but goodwill in the accounting sense is only recognised in the balance sheet when a company purchases another enterprise. 2, a business may...
Sorry,
I'm so sorry.
I'm struggling to keep up. May have goodwill in the commercial sense, but only recognised in the accounts if there is a...
Well, goodwill, all businesses may have goodwill in the commercial sense, so they have the attractive force that brings in custom. Mm-hmm. But goodwill in the accounting sense is only recognised in the balance sheet when a company purchases another company.
Yes. Thank you.
Now, the second proposition is that a business may have goodwill in the commercial sense, but no goodwill in the accounting sense will arise if its enterprise value, by which I mean the aggregate value of the company as an ongoing enterprise, does not exceed the value of its assets. So I can illustrate that by, say one considers a persistently loss-making company, but which has a good reputation. So that business may have goodwill in the commercial sense, but its enterprise value may not exceed the value of its assets. So if the company is sold at its enterprise value as a going concern, no accounting goodwill would arise for the acquiring company because the purchase price would equal the value of the assets acquired. And the final point that I make in this context is that not all of the factors which justify recognising accounting goodwill would be classed as goodwill in the commercial sense. So, for example, the PwC guide, which we looked at, explains that deferred tax and employee benefits may be included or as factors giving rise to goodwill in the account.
You have to say that again. What was the example in the PwC?
Deferred tax, I'm asking your lordships and my lady to memorise this, which is thoroughly unfair.
Perhaps we should turn it up.
If we take it out, it's the second bundle, right at the back, page 105. The learned friend took you to the paragraph in the middle of the page, where there are 3 bullets. And as my Lord Justice Henderson pointed out, yes, of course, this context is all in that specific acquisition of a company context. And all I'm pointing out here is that not all of the factors which justify recognising accounting goodwill as that plug-in number into the post-acquisition accounts are things that would necessarily come within the concept of goodwill in a commercial sense. So, for example, deferred tax and employee benefits, we say, plainly wouldn't fall within the usual commercial concept of goodwill or Lord Macnaghten's definition.
Could another way of testing this be to look at a well-known context where goodwill matters in legal terms, and that is in the context of passing off claims? I mean, in order to bring a claim for passing off, the first thing you have to establish is you have an established goodwill. And if a company comes to court trying to stop some fellow trader from ripping off its products by passing them off as your own, I mean, you don't expect the evidence and support to be, here are the company accounts showing an accountancy figure for goodwill. On the contrary, it will be given a whole lot of evidence about the way the trade operates, numbers of customers, etc., etc. Which really makes the point that the commercial goodwill is really something very different in ordinary parlance from a rather artificial accountancy concept, which is really only employed upon an acquisition of one enterprise by another.
My Lord, yes, and in the example your Lordship's just given, perhaps it wouldn't even be possible to put forward accounts if there hadn't been a prior acquisition.
Well, absolutely. It may not have been a private, so even assuming that there had been, it's not the first thing you would draw to the judge's attention on a new application for an interim injunction.
So,
if you were to-
so we say for that reason, goodwill just in that accounting sense does not fall within the concept that the parties should be taken to have objectively taken to have agreed in this contract, because of course that's what we are always need to be grounded by reference to. If I then, I'm just going to expand on the nature of what the claim is, because I think in particular my Lady Justice Carr asked about how her ladyship, Mrs. Justice O'Farrell, dealt with this below. I don't think I need to take the court to the pleadings, but it's perhaps worth looking at the two judgments. So if the court could take the court bundle and turn to paragraph 486 is where the section begins, page 175.
Page 1.
175, my lord, the bundle.
Yes.
So that's where quantum begins, and if we orient ourselves by reference to Lion Nathan, which is the decision of Lord Hoffman.
Before we look at the passages in the judgment, my note is in this case our claim was.
Our claim.
You're going to give it to me in a sentence before we look at the paragraphs in the judgment.
Well, our claim was that we overpaid.
Okay, thank you. And then we're looking at
488. And I asked the court just to read that quote.
Forgive me, your primary claim, paragraph 42, page 235, was that your loss and damage was to be measured by the difference between the value of the shares as warranted and the true value. Further, alternatively, without prejudice to the foregoing, loss and damage to be measured by reference to what the claimants would have done had the forward-looking projections been carefully prepared. So your secondary case was...
Well, that case is only open to me on the breach of warranty 19.5 because...
you're quite right, yes.
I could come to that. I was going to... Well, no.
No.
It simply... I put it this way. I've touched on it already. Lion Nathan sets out the sort of starting point that her ladyship adopted below. And we cited that because there were effectively two warranties of quality, which was as to the state of the company, the state of the permits, and the state of the lack of operational defects of the shipmans. The third is this reasonable care was taken.
Yep.
Now, in Lion Nathan, Lord Hoffman explains that in that first paragraph extract that my ladyship cited below, prima facie, you're entitled to the difference. So in a case of a warranty as to the quality of goods. But on the other hand, I'm moving on to the second paragraph. If one construes paragraph 32 as a warranty that reasonable care has been taken, then he goes on to say there's no analogy with the warranty of quality, and you just go back to the general principle.
Yes.
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 So now to pick up on what my Lady Justice Carr pointed out, it's quite right. We had a go at paragraph 42 and saying that, well, we'll go for the diminution full stop.
Well, you alleged many more breaches of warranty
Absolutely.
and failed. Yes.
Yes. But on warranty 19.5,
Yes, I see that.
I said, well, look, you've just got to look at what we would have done. So if that's the one we win on, the court's got to take a step back and say, well, what would have happened? Now, if you look at just towards the end, perhaps towards the foot of the page, 175 in the judgment, where Lord Hoffman describes what had happened in that New Zealand case. In this case, the vendor represented the purchaser that 2.23 million was a figure upon which he could rely in calculating the price. That figure was in fact used in the calculation of the price. If the vendor had made a forecast in accordance with the terms of warranty, he would have produced a lower figure and the price would have been correspondingly lower. And then, so in that case, because it was a forecast, the court looked at what the lower figure would have been and then the damages are therefore the difference between the price agreed on the assumption of the 2.223 million earnings and what the price would have been using the same method of calculation if the forecast had been properly made. So then the judge below said at para 490 how Triumph had agreed the purchase price, and that my learned friend was at pains to go into the assets and so on and so forth, but her ladyship didn't make any findings of that sort, and she explains at 490 how Triumph had agreed the price by referencing its own financial model. Then at 493, her ladyship explained why in her judgment the DCF approach was appropriate, because the Primus values of companies were sold as a going concern. They remain in active business and their value lies in revenues driven by production, rather than the value of the underlying assets. And then they go on to make the points about relying on the DCF valuation and the evidence that the decision to purchase was based on the future profits forecast in the LRP, which my Lord Justice Henderson has pointed out. So with that context, her ladyship went on and had already pointed out, of course, the errors in the LRP, and she directed that a new DCF should be carried out. And if the court could look at the conclusion at page 498, sorry, it's a rather long-winded way of coming to the nub of the point at little Roman 9 on the final page of the judgment. The court will see that what Mr. Justice O'Farrell has done there is effectively echo the wording in the final paragraph of Lion Nathan. And the exercise that was to be carried out, therefore, grounded in that authority, was that a new careful forecast be produced by the experts, and then that will be plugged in to the calculation using the same methodology, and then a price would be achieved. So there was a two-tier process. I fear I'm still answering my Lady Justice Carr's question, because it wasn't just an expert valuation. And so with that founding, if the court could please move on to page 190, which is in the quantum decision. And again, para 59 explains the difference, explains the conclusion which we've just looked at, little Roman 1 and 2. And there, her ladyship explains the process that has gone on. So, first of all, again, echoing Lion Nathan in 59, and what we said, as is recorded at 62, is that, well, look, putting in figures from a carefully prepared LRP into the Triumph model produces a lower figure than we had at the time of the purchase. And a dollar for dollar reduction in the purchase price is the right answer, as a matter of fact. And her ladyship held at 64, Triumph would have reduced the purchase price to reflect the reduced DCF value, and Primus would have agreed. So my lady, that's my long-winded way of saying it was both. There was an expert assessment and then a factual assessment to say, well, right, you'd have got this lower figure out of the machine. Now what would you have done with that? Well, we would have gone and said we're paying less. And that's what her ladyship concluded. And she gives her reasons going through to 71, but I don't think we need to go into that. So that, we say, is why this isn't a claim for lost goodwill. It's a claim for loss of money. And we say that the court's determination of whether warranty 19.5 had been breached did not have to consider any matters relating to goodwill. And in particular, this was not a claim in respect of loss against the plug amount in TGI's accounts. And it's nothing to the point that TGI's goodwill at the consolidated level in its aerospace segment was impaired 3 years later. because that's not what this claim was for. Can I then just move on to what I said about how it's very unclear to which assets or to which warranties this loss of goodwill exclusion could apply? It just requires a short look at the SPA. My Lord Justice Coulson looks.
No, I'm just concentrating. So we're looking at the SPA.
The SPA, to the back of the core bundle, tab 17, the warranties, they are at page 317 onwards. And the real purpose of doing this is really to ask or to illustrate that it's not clear how the loss of goodwill exclusion would operate in the context here, in circumstances where a claim can only apply, on the learned friend's reading, to the tangible assets and their value, and intangible assets and their value in the accounts post-acquisition. So if we look, the first three warranties are carved out, so it doesn't apply. But for example, in relation to a warranty about the constitutional corporate documents, page 319.
319.
Yeah. We see that there's a warranty about constitutional corporate documents. Now, it's not clear how a claim in relation to that would fall against only tangible assets or assets in the balance sheet post-acquisition. Moving on the next page, licenses and consents. It's not clear which of these could have any value ascribed to them in the accounts. We couldn't find an entry in relation to this.
Sorry, where are licenses and consents?
License and consent, my lady, at page 320, warranty 6.
Thank you.
It's not clear, again, how the disputes and investigations.
Oh, yes.
Now, perhaps as a contradistinction to this, the court could look at warranty 12, page 322. Now, that does deal with assets. Warranty 18, about property, particulars in the schedule. Now, we can see that those deal with assets. But if my learned friend's case is right, then surely the drafting would have been different. We've seen 19.5, and my learned friend's also touched on the anti-bribery and corruption warranty at 25, warranty 25 at page 330. That really is what I drew my hypotheticals from at the top of my submissions. But again, it's not obvious how a claim could be brought for breach of that warranty. And we say it's absolutely crucial in relation to the importance of the 19.5 warranty, given that the forward-looking projections are what charted the route to profitability and the entire offering over a 5-year horizon. And we've dealt with some more at my skeleton at paragraph 57, so I'm not going to go through that anymore. I'll sum up with it on this point, is that had the drafters of the SPA intended to exclude all claims other than those that the buyer did not receive assets of the value as warranted, then that could have been achieved far more simply. The SPA could have excluded any claim other than a claim that the true value of the assets of the companies were less than the sellers had warranted. There could have been a specific reference to the post-accounting treatment, but it would have been easy to put in, we say. And if the parties had intended that a claim for damages of warranty 19.5 could be excluded, then we say that the court would expect to see that set out clearly, and the fact that the exclusion clause doesn't take the clearest and simplest route here demonstrates the fallacy in my learned friend's argument. Can I just want to pick up on one point on the authorities and the contra proferentum point. all I'll say about that is that it is still open to the court on my Lord Justice Briggs, as he then was, analysis in the Hutt group, that if there is ambiguity, the court that may have to be resolved by a preference for a narrower construction. But that's only if linguistic, contextual, and purposive analysis do not disclose an answer to the with sufficient clarity.
But you're really running a Gilbert Ash point, aren't you?
Yes.
You are really running a Gilbert Ash point.
I really am, my lady. It's my 2 points are yeah, we're not likely to be taken to have intended to cut down this remedy for this important warranty in the manner that's suggested. And finally, though I put this point as absolutely supplementary, but we had the magic phrase in the skeleton. If there is any ambiguity, we say that applying commercial common sense in support of the basic linguistic analysis also supports Triumph's approach. My lords, my lady, that's what I was going to say in relation to meaning, because we've covered meaning and also the consequences and the absurdity of the construction argument. I can deal pretty shortly with consistency. We've dealt with it in the skeleton, but all I was going to say that if one looks at clause 13 of the SPA, and we can look at it shortly.
Yes.
Look
at clause
13,
Yeah.
which is SPA tab 17, page 298. The skeleton reference for the court's note is at paragraph 60, and we cite Lord Justice Lewison in the Bernardo's case as to the consistency principle. I don't need to turn that up. What's at clause 13 is, as my learned friend says, a pretty standard undertaking not to compete for a set period. And then at 13.4 is the acknowledgement from the sellers that the undertakings about non-competition are reasonable. And that is, of course, to head off to head off complaints that this is an unenforceable clause, and because the remedy that's usually used is that you go and get an injunction. And we say that the reference there to the purpose of protecting the goodwill of the business is exactly what's being protected here, which is the ongoing goodwill and reputation in the commercial sense, because that's a means by which the purchaser secures to itself the advantages it was intended to have from what it's purchased.
And Mr. Morgan says that this is about protecting the, as it were, the past/existing goodwill that has been purchased, so the value that has been purchased. It's not about protecting the future ongoing goodwill. What do you say to that?
Well, I'd say that as a matter of construction, that doesn't work, because what's happened is, and has happened in the present case, you buy an ongoing concern, and you're buying the ongoing value of that business. Now, Triumph was buying companies in Farnborough and Thailand which were producing parts for Rolls-Royce and Airbus, amongst others, and plainly had an ongoing goodwill and commercial reputation with those people, so that these big producers would buy our parts, or buy the parts of those companies. That's ongoing goodwill.
You say the flavour, the 2-year period in 13.1 is all, do you say, consistent with this ongoing concept?
My lady, yes. And we also say, just to tie up, because it's a consistency point I bring this in as, that it can't be suggested that goodwill was intended to bear two different meanings within this contract. It would just, and particularly within the same clause, because of course goodwill appears in Schedule 8 as well.
I mean, it's not conceptually impossible for the same word to have different meanings in different bits of a lengthy agreement, but on the whole, one starts from the presumption that in a carefully drafted document drawn up by lawyers, words, particularly words with a recognised legal meaning, will have the same meaning in the absence of a contrary indication.
My lord, yes. Yep. That was where I had got to then, I think, on the key points that I wanted to cover, apart from the respondent's notice. And again, I mean, I don't have much on it, but it's been a long morning. I don't know what the court...
Well, obviously, I mean, how long do you think you will need to deal with that?
2 minutes.
2 minutes. Well, that's not very long, is it?
We deal with
we can
this.
certainly get. We can get through that before we break.
We deal with this in our skeleton at paragraph 62 to 66, and I say that for the note. We say that all this means is that even if it applies to goodwill in this broader and incorporating the accounting sense, I appreciate my learned friend is not saying that it's a distinct sense, but it's incorporated. It does not apply because the claimants were not bringing any claim in respect of the goodwill of the companies, and we say that goodwill in the exclusion clause applies to the goodwill of the companies in this alternative universe. We have just looked at paragraph 13.4, how goodwill being protected was out of the business of each member of the target group, and if the court remembers, at the very beginning, my learned friend took the court to that structure group. The target group effectively is the companies plus one of the other Primus companies. So that's not goodwill of TGI, the purchaser, it's the goodwill of the companies. And so we say that if the claim is probably understood as having been in respect of goodwill that has been lost on TGI's books, then this clause doesn't bite, because when the claimants were not bringing any claim on behalf of the TGI, they don't refer or rely to any loss of goodwill by TGI in their claim. TGI was not...
So say again.
The claimants haven't relied on any loss of goodwill by TGI, the group company. TGI, Triumph Group Incorporated, because that's where goodwill has been impaired or lost.
It was bringing a claim for its overpayment. Is it going back to that point?
So, but it wasn't a claimant. TGI,
Yeah.
Triumph Group Inc. is the American group holding company which has produced these accounts, and in where my learned friend has pointed out goodwill was impaired in 2016. That's not the claimant. And the claimants are not relying on any loss of goodwill in relation to TGI. There's no reason to construe the lost goodwill exemption as referring to goodwill that's recorded on the balance sheet of any entity other than the parties to the SPA or the companies.
I mean, it's on its face at page 376, it just says it's open-ended. I'm anticipating what Mr. Morgan's going to say.
Yes, it is.
It's any lost goodwill.
Yes.
But you say, in a nutshell, why should this be construed as
applying to...
as applying to the companies only?
No, we say it's applying to only the companies,
Yes.
because it's common ground, and it's common ground that the companies had no goodwill on their books when they were sold. My learned friend has said in his skeleton, well, that means that, on my reading, it would be OTOs, but the point that the companies had no goodwill just means there was nothing to bite on the facts of this case. It's not rendering such a clause OTOs, and that's unlike what we've described in relation to warranty 19.5, because the effect of Primus's argument is to cancel out a protection.
So you say it can't be the companies because they had no goodwill if you apply the accounting definition. Is that right?
No, I say that the goodwill here is the goodwill of the companies that's referred to, and the companies had zero goodwill, so therefore
And
the
they
loss...
had zero goodwill because...
well,
On the facts.
on the facts that, sorry, yes, it's in their accounts, as at the PEG accounts show that at the date of the contract,
Right.
there was zero goodwill in the companies. And our claim...
So the exclusion clause has nothing to bite on, you say?
Exactly.
Assuming that the
He's right.
accountancy definition applies.
Yes.
Yes, we have to imagine ourselves into, as it were, the appellant's world to,
Well, it's
to
been
get onto
very
this one and notice.
difficult, but yes, it's in that context.
Yes. Okay, thank you. So, does that conclude your submissions?
No, yes, unless there's something else I
Any
can assist.
questions from my lord or my lady? No? Well, thank you very much indeed, Mr. Pillai. Now, Mr. Morgan, it's already slightly after 1 o'clock, so I imagine you've got to reply on the respondent's notice and reply generally on the, how long do you think you're likely to be?
I would think it'd be about 15 minutes or so.
Okay, well, in that case, we'll rise now and come back at 2 o'clock, if that's all right for everybody. Thank you very much.